Let's move on to the next slide 5. I'm starting with a few what I call uncontroversial propositions, really as foundation for the more difficult parts of this lecture. The first proposition, which I think is now generally accepted, is that there exists an international or transnational public policy. And that public policy declares that if corruption is proved in the sense of actual bribery, then that will nullify commercial contract. There are many cases one could pick on. Funnily enough, of course, most arbitration cases cannot be used as authorities because the awards are confidential, so they're not usually published. This is an arbitration case, an exit arbitration case, but it was decided not pursuant to a treaty, but under a contract, and the governing law was English law. It's called World Duty Free Company against the Republic of Kenya. We'll come back to that a little later, but I'm just citing it at this moment as authority for a proposition that an international tribunal has declared that bribery is contrary to the international public policy of most, if not all, states, or to use another formula, the transnational public policy. For those of you who follow international law, I think the recent publications of the International Law Association, which are normally very influential in the development of public international law, make it quite clear that there is such an international or transnational public policy. Secondly, on slide 6, jurisdiction. Now, there was a time, particularly in civil law countries, when arbitration tribunals would shy away from issues which they thought belonged for determination in the courts. Typically, forgery and corruption were among those topics. But that has changed, and it's generally now accepted in international arbitration that issues of corruption are arbitrable. In other words, that the tribunal is properly competent to try whether or not there has been corruption. And even if the corruption will nullify the main contract, the tribunal still has jurisdiction because, of course, the tribunal's jurisdiction comes from the arbitration agreement contained within the main contract, which is in law considered to be a separate contract, which survives the nullification of the main contract. The third proposition is that if you base a claim on corruption, or rather, yes, if you make a claim that arises from a contract procured by corruption, then you can be knocked out at the threshold simply because the tribunal will say that you do not deserve the tribunal's ruling on the merits of the case because you have forfeited your right to that hearing on merits by virtue of the fact that the contract is tainted or infected by corruption at its source. Of course, in common law, we call it the ex turpi causa doctrine, but in public international law, the doctrine is called the clean hands doctrine, but essentially they are the same thing. The fourth uncontroversial proposition is that the merits of a dispute are, of course, dealt with by the applicable law of the contract. And I use the word applicable very carefully, knowing that Professor Yeo is sitting at the back, and whispering to himself, because one could use governing law, one could use all sorts of phrases, but at the end of the day, of course, I'm ducking the real question as to what the applicable law is. And after Professor Yeo leaves, halfway through this lecture, I shall tell you. The final point on slide 6 is that contracts tainted by corruption are void or voidable. Now, there is a difference between void and voidable to all common lawyers and even, I think, civil lawyers. But in the context of corruption, it's more important possibly in treaty arbitration than in commercial arbitration. The significance is this: if corruption destroys a contract, then nobody can claim any rights or hold a party to any part of the contract. But to take the World Duty Free case as an example, What happened in that case was the claimant had the franchise for duty-free shops in Kenya, and the Kenyan government then appropriated it, so he sued for breach of contract. And then the claimant, for some reason, which there is hotly debated, actually said, and one of the grounds of my expropriation, for compensation for my expropriation, is that I paid your president a large sum of money to get this franchise. Now, the interesting question then was this. It was not seriously disputed that money had passed between World Duty Free and the then President of Kenya, Daniel Moi. But the question then was the country responsible for the malfeasance of its president? Now, if the country was responsible, then the country might have been either held to have waived its right to raise the corruption point, or to be stopped if they hadn't taken action. So those are the two standard doctrines that come into play when corruption is introduced in a treaty claim. That if a claimant comes and says, I obtained this contract by a bribe, then typically a tribunal will throw him out. Unless it is said that that corruption, which nullifies or precludes him from suing for the substantive right that has been violated by the tainted contract, has in some way been overlooked, forgiven, or simply forgotten about by the employer, the state employer of the person who took the bribe. So that's where the voidable question comes in and becomes of importance. So that's the easy part. Let's get on with the difficult part. And let's get to the core of the matter, slide 7. I told you we're talking about agency or intermediary agreements. What we are talking about here, of course, is you have a foreign company, typically either in oil and gas or in the armaments industry, and they want to sell their products to a government agency within a country, and of course it can be anywhere, but interestingly enough, most of the case law that we've come across have been in Asia. So let's just take Asia as the geographical region that we're going to be talking about. And the first question that we want to address now is moving on to slide 8. Again, we start from a foundation which is not controversial. If there is a contract and the contract either expressly or impliedly says that the agent or intermediary who is employed to represent the foreign company in the host country is to use bribes to procure a contract for the foreign party, for his employer or client, then that contract for his remuneration would be unenforceable. And that would apply whatever the applicable law is. I mean, I haven't searched 150 national laws, but I think generally speaking, no one has put up his hand to say that they are an exception to that principle. The difficulty comes when you have contracts where